Welcome to the 266th session of Legal Empowerment Through Interaction lecture series. A wonderful topic indeed. Shared parenting, need for formulating practice guidelines. It may look good on paper, like shared parenting and things like that, but on the practical plane, end of the day, it is the child which matters. How far and to what extent and how we can. These are the issues that we might think of and deliberate today. And we got a wonderful panel in the sense like deliberations will be led by Justice Vijender Jain sir, who's a former Chief Justice of Punjab and Haryana High Court. And we have two experts in this field. One, of course, the master in the sense like, say, Anil Malhotra sir and Mrilanli Deshmukh ma'am. Both of them have been in this platform, and we have been indeed privileged by the exchange of ideas and thoughts that they were able to offer. And today we are privileged with the presence of Justice Ramakrishnan sir and all of you, wonderful participants. And so without wasting any time, this being a thoroughly informal platform wherein what matters is only deliberations, discussions, and in-depth analysis of the topic alone, may I request Honorable Mr. Justice Vijender Jain sir to deliver or enter the introductory remarks. So over to you.
I'm really glad to be a part of your endeavor, which you have experimented during COVID. It is COVID actually has made in all spheres except the pharmaceutical companies and big persons who are connected with paramedical things and other things. Rest of them, they have said, all right, you sit down, use only video conferencing. So whether they are lawyers or judges, I'm sure inertia has set in. In this, your endeavor, Mr. Shyam, and when I saw Padman, so I thought that it has to do with your activity because you must be carrying always your laptop or something with you. So in these 2 years, having 263 or 266, if I'm correct, 266 webinar on various aspects of law is really remarkable. And when Mr. Anil Malhotra, he told me that this is how he has been interacting through these webinars, which has really become a source of data regarding legal issues involved in the life of people, consumer of justice, as well as people who are practicing law and who are administering justice. So he said, and I said, all right, I will join you for a few minutes. And you know what he told me? You have not to speak. You have to only chair. Because other my distinguished friends here who are the keynote speakers on this subject. It's a very interesting subject which you have chosen for your today's discussions and understanding. Because debate in this regard is going on for decades. I don't like to say many things because the people will like to hear from the experts. My experience as a lawyer, as 20 years as a judge, all kind of laws, though we talk about the welfare of child, but have we achieved that through either our legal bills, acts, and pronouncement by the court or not, that's a big question mark. Now, there are always two opinions of the why not we can't have joint custody for a child, because after all, there is, let us say, disharmony in the family. Marriage is disrupted for A reason or B reason. Apart from the person, spouse who are fighting each other, it is the child who is most affected in it. We talk about legal custody. We talk about not non-legal custody. But who is the sufferer? In certain cases, I have seen that a child who has been given a legal custody to the mother. Now, father has got visiting rights. Now, the visiting rights, they say on Saturday at 11:30, the father will come, take the child, till 6 o'clock, he has to return the child. Now, in law, it is a joint custody because the father has got the visiting right and the mother has got the legal right to look after the child. Now, but the child, for example, let us say he doesn't want to leave at 11:30. He wants to go, he's playing or not got up or have got some other place to go. Now, he has to be there at 11:30. This is what I am talking, some of the problems which is faced by a child. So if there is a law which can formulate and courts are capable of giving guidelines in terms of those, for the child welfare, what is paramount important, what is the need of it, we legislature, courts have to look towards it. I don't want to go into the enactments of the old colonial law of 1890 or the new act which has been formulated. I will leave it to the speakers to speak on those issues. But there has to be a harmonious relationship of law with the life of the child. How we can manage that? As the article written by Anil says that in UK, Australia, they have got a law to have that both parents have a joint custody of the child. But on the other hand, Japan and other countries, they are not having joint custody of the children. So this is the issue for which you have organized this seminar. I'm very happy to associate myself with it. Perhaps Anil has not told you that I underwent a open heart surgery. So I told him that I will be limiting myself for some time to be here, and I would like to enjoy hearing the expert on this subject. With this, I inaugurate your webinar. Thank you very much.
Thank you. Thank you very much, sir. And the passion with which you are able to introduce the subject, and that will be taken upon by the experts today. The issue is regarding a child. It's not a chattel. So, end of the day, when it comes to deciding, is it for the individual just to decide? Is it for the parties to decide? Is it for the legislature to decide how it has to be? Today, we'll hear it from the experts. And I'm grateful to you, sir, for having spent the time with us on this introductory remarks. And let us move on to Anil Malhotra, sir. Please, sir.
Thank you, Sham. I'm very grateful and indebted to Honorable Justice Vijender Jain for coming out of his period of convalescence and being indisposed to inaugurate this very important occasion. I remember Honorable Chief Justice Jain, even while he was a judge, despite his preoccupation with judicial work, administrative work, he found time for social issues on weekends, and there was never an empty weekend on which he was not addressing the social issue. Thank you, sir.
No, you can also remind that when you organized that seminar,
Sir.
and you also wrote a book with
Sir.
regard to the plight of the NRI women.
Sir.
You sent me photograph today, and I remember that we had a very successful things, and we created a special court in Punjab after your seminar, because more than 25,000 women who are married to NRIs, they were abandoned.
Sir. So on this note, let me share with you, we have a common issue with Kerala. Abandoned NRI brides, or popularly known as holiday brides in Punjab. Now, at that point of time, the problem was a very big social issue. And I, as advisor of the NRI issues of the government of Punjab, had compiled a booklet, and we had organized with the help of the governor of Punjab and Honorable Chief Justice a seminar on. We had a full day interactive session in which we heard the various issues, and then Honorable Justice Jain was very, very passionate about resolving the matter. So he set up a special court, and fast track hearing of matters took place. And ultimately, Punjab is probably the only state to have a Punjab Compulsory Registration Marriages Act, by which this social issue was sought to be checked. So Honorable Justice Jain's endeavor goes back to my association with him in 2007, and the pictures of which I have shared with Nalini ma'am and Sham also, that this was his impetus, this was his drive, this was his motivation on social issues, that he was alive, even though he was a judge, he would not hesitate to come on a social platform to help people ameliorate their grievances and provide solutions in the best possible way, maybe by structuring of courts, maybe by fast tracking of mechanisms or additional courts. And we also have now NRI courts whereby these issues are taken up in the fast track. Now coming on to the issue of children. United Nations Convention on the Rights of the Child was signed by India, and we amended the Juvenile Justice Act to carve out a definition of the best interest of the child. Now, if our children are our future, why are we not trying hard enough to build their future? It is easier to bring and repair strong children than to leave them in misery. Why can't we repair broken marriages? Children are the most important thing in your life. They can change you, they can make you, they can break you. Now, what is disturbing? What is discomforting? What is going wrong? In 2017, Justice Sikri and Vivek Singh and Romani Singh identified parental alienation syndrome as a serious psychological disorder which erupted when children were alienated and polarized on account of separation of persons. I have noted that there are 4 judgments in which this is the proof of the pudding has come in the way of the pronouncement. First is Jitinder Arora versus Sukriti Arora, 2017 Supreme Court 957. Now this is a case where 2 children were separated. The younger daughter was with the mother in England. The elder daughter was with the father in India. Once I was in London, the lady had met me and tried to sort out the medical issues of the child and what possibly could be done. But the litigation had gone on so long that when the matter was finally heard, the lady broke down in court because the elder daughter didn't want to see her anymore. And that was a sad story. The family split. Then came Prateek Gupta and Shilpa Gupta again in 2017, where again 2 children were separated. And the separation period, because of the litigation, led to such a gap that a long period of time had elapsed, and The child in India did not want to see the mother abroad and did not want to go with her. So then the matter was left to linger in the family court and maybe probably another miserable period of litigation. Now, then we saw Smriti Madan Kansagra's case. Now, this was a case between Perry Kansagra and Smriti Madan Kansagra, where after a 12-year litigation, the father was allowed to take the son back to India, back to Kenya, on the condition of a mirror order. 1 crore rupees was deposited in the Supreme Court registry. But when the time came for him to honor the mirror order, he refused to comply with the order, and the child refused to return the child to the mother in Delhi. She complained to the court. The court issued him notice. He did not even appear. The result was that the Supreme Court recalled its judgment. Now the man said, I have suffered so much, so now I am not going to honor this verdict. Again, a case of parental alienation. Then is the most significant case which has happened in the Supreme Court on 27th of January 2022. This is Gelna Khambata versus State of Maharashtra. A Bombay High Court judgment in a habeas corpus petition on behalf of the mother in the US wanted her 2 daughters back. I read the judgment which was provided by Munalini ma'am. It is a battle of litigation. It's a Parsi couple fighting over what law is applicable, whether Parsi law or English law, American law. How is the continuing litigation in both sides to go on? There are anti-injunction suits, there are divorce petitions, there are matrimonial settlement, and there is a brilliant amicable settlement attempt by Justice Rajiv Dar, Honorable Chief Justice of our High Court. Everything fails. So ultimately, the division bench of the Bombay High Court says there's nothing we can do. This habeas corpus will not succeed. The matter goes to Supreme Court. The petitioning mother, through her counsel, tries very hard to reconnect with her daughters. The first bench held by the Honorable Chief Justice makes an effort, gets the daughters online, and tries and talks to them. They are 15. There are one girl is 18 and one girl is 15. Now they have spent almost 3 years in India. They don't want to see their mother. So the petition is dismissed. Now, where are we heading? What is going on is the question which bothers me and which puts me into a dilemma about what is the law going to do about it. The other issue I see as a practitioner on the side is our courts think of unilateral custody and choose mother or father as the custodian of the child and hand over the custody to that parent. The result is that when the time comes for the other parent to have his parenting time, I don't use the word visitation. I think visitation is to be used when you visit somebody in prison. When you want to meet your child, you are not doing a visitation. You are not doing a formal visit. You are doing parenting. So coming back to the topic, when you want to have your parenting time with the other parent refuses to honor the agreement. The child is not brought on video call. The child is not available for a visit. The child is not available to see the parent. So there is frustration. And in the pandemic times, redressal and approach to courts is becoming difficult. I did a matter which was widely reported in a habeas corpus decision, in a habeas corpus petition, where the mother had purportedly taken the children to England, but when the father visited the home in India, he found one of the children there. He moved in habeas corpus, custody was awarded, but then the Supreme Court stayed the order, so we are back to square one. So the effect is that there is something amiss in the whole scenario of this litigation, where we need a workup, where we need to do something. Now, Justice A.P. Shah did a brilliant job in report number 257 and then report number 263, where he gave us exhaustive amendment of the Guardian and Wards Act and the Hindu Minority and Guardianship Act to do away with the concept of singular custody, to introduce joint parenting, to introduce co-parenting, shared custody, and rights of parties and duties to children. But that, again, has never seen the light of the day. The Law Commission's reports is lying in the government archives gathering dust. Then came Justice Bindal Committee, of which I was also a part. We looked at the issue of interparental child removal. After a child was moved to England, I was an amicus for 12 long years. Nothing came out of it. So on a report submitted to the Law Commission, the committee was formed. We went into the issue, heard left behind parents, heard parents in custody of the children, gave a 2-volume report, recommended that the interparental child removal be defined, safeguards be set up, a mechanism be set up, and a bill was drafted and put in the 2-volume report. But again, we are where we were and nothing is happening. So now left with this scenario, left with this predicament, I have started to reading between the lines and trying to make the best of what we have today to see how the law can move forward. Now, it is in this context that my thinking out of the box has led me to this ideology, which I will put before you today and for the kind consideration of all people who are attending this webinar, to see where is the path forward. A division bench of our High Court, headed by Justice Ritu Bari, has also asked the government to look into these issues and see if joint parenting is possible. But I think enactment of a law is very far away. Parliament will probably never have the time. Where the law makes money, like the Arbitration Act, it can be amended very fast. But when it relates to children and when it relates to marriages, I don't think anybody does anything. So it is in this context, let us go to the existing structure of the law and see what can we do with this law. So the first proposition is Section 3 of the Hindu, we all are Hindus, and most of us are governed by the Hindu Minority and Guardianship Act as our personal law. So Section 3 of the Hindu Minority and Guardianship Act, first of all, says that it is a supplementary law and it is supplemental and incidental to the Guardian and Wards Act and not overriding or in contradiction to. So therefore, the settlement is that the Guardian and Wards Act will be the overruling provision of law, and happily or unhappily, for wisdom best known to the Parliament, the Hindu Minority and Guardianship Act does not give you any route or statutory right to go to a court. So if you have to file a petition for guardianship or custody, you have to vest your right through the Guardian and Wards Act, read with the Hindu Minority and Guardianship Act. Now, Section 2B of the Hindu Minority and Guardianship Act talks of the definition of a guardian, and it includes a natural guardian. And Section 6 of the Hindu Minority and Guardianship Act, which is the most interesting provision and which on I think the whole fulcrum rests, is it defines who is a guardian. It defines what is the guardian's role. It says that the natural guardian of a child shall be the mother and father, they are both equal, provided that the custody of a child less than 5 years of age shall ordinarily be with the mother. Now, this gender mindset has got so entrenched in our system that the courts do not generally even look at the custody of a child shared or with the father if the child is less than 5 years of age. But there is a proviso now. Lahari Sakha Muri's decision 2019 7 SCC 311 says that the best interest of the child cannot remain the care and love of the primary caregiver, i.e. the mother. So the gender, the maternal preference has been in a way disapproved in Lahari Sakha Muri. Then we come to Vasudha Sethi, the latest decision in Criminal Appeal number 82 of 2022, decided on 12th of January 2022, where the Supreme Court says that the court can disturb the custody of the mother if it is not in the best interest of the child. and the welfare of the child gets preference over the rights of the parents. And wherever this happens, visitation rights will be given to the other parent for child welfare and not rights of parties. So where is this paradigm shift coming? This shift is coming in the Supreme Court's view in watering down and diluting the gender preference. I was an amicus in this case, which was decided by Honorable Justice Tyagi at the High Court. The High Court judgment has been upheld. Now, this is a clear indication that the Supreme Court has started saying that Section 6 does not give a parent any vested right of custody. So, what is it that takes the crunch? Section 8 SMGA, powers of a natural guardian. He can't be displaced. Section 13, welfare of the minor will be the paramount consideration. Now, let us come to the Guardian and Wards Act. Likewise, the Guardian and Wards Act in Section 4.2 defines the guardian. Then under Section 7 is the power of the court to make an order for guardianship. And Section 8 is the power of the person entitled to apply for the orders of guardianship. Now, the Guardian and Wards Act 1892, which is a colonial law, which was probably made by the British to suit their ends in resolving custody matters when we were colonized by them. But unhappily, we have carried on with this colonial law without even thinking that a child is not a piece of property which one parent can possess and keep like a table or a chair in his or her home. A child is also a person. Think of the child in a child-centric jurisprudence and decide his rights. What happens in any child custody case, be it habeas corpus or be it Guardian and Wards Act? It is more of a mudslinging fight between the couples. There is no talk of the child. So, what does the court do? Get caught in that trap, and it decides which parent has a superior right. As Justice Jain was putting it, the harmonious balance is lost. The court decides when the father or the mother will have visitation. But does anybody look at the child? When does the child want to be visited? This is an excellent example which Justice Jain gave. Nobody looks at the child. So, what is happening in our country? The litigation is more of a decision on the rights of parties, not on the rights of the child. So, therefore, let us look at the law as it is and let us try to see where the family courts can change. Now, if we read Section 12 of the Guardian and Wards Act, I'm going to read this to you because I have myself changed my way of looking at things after reading and rereading Section 12 of the Guardian and Wards Act. Now, Section 12 of the Guardian and Wards Act is power of the court to make interlocutory orders for protection of the child and protection of his personal property. So it says, the court may direct that the person, if any, having custody of the minor, shall produce him or cause him to be produced, and may make such order for temporary custody and protection of the person or property of the minor as it thinks proper. Now, I repeat the words order for temporary custody. Now, I have just read out to you that the father and mother are natural guardians. So the right of the natural guardian can't be done away with because that is a right which vests in you as a parent, as a natural parent of the child. So why can't we look at such order as a shared custody order or a joint parenting plan? Why does the court always think of singular custody when we look at the word order in temporary custody? So if the family court were to read in the words joint parenting, shared custody into such order for temporary custody, I think the problem can be looked into with an open mind and a child parenting and custody order may result. Now, Section 17 of the Guardian and Wards Act again talks of the welfare of the child in appointing a guardian and paramount consideration being the Section 26 of the Hindu Marriage Act also talks of orders for custody of the child. Now, who is to do this? Where is this to happen? Is the crunch. Now, if we look at the Family Courts Act, I think there is wholesome power in the Family Courts Act with the family judges to do what I said. So shared parenting, joint custody can be read into Section 12 by what mechanism? By an inbuilt power conferred in the family courts under the Family Courts Act. How do I say so? First of all, Section 7 of the Family Courts Act gives the jurisdiction of the court. Now, Section 7, 1 explanation G says that the jurisdiction of the family court insofar guardianship, custody or access to minor. So where is the family court's jurisdiction? 1, guardianship, 2, custody, 3, access. So the family court has 3 missiles in its arsenal. 1, guardianship, 2, custody, 3, access. So this is the wholesome power of the family court. How is this power to be exercised? Section 9, duty of the family court to make a settlement. Now, when the family court has a statutory duty under Section 9 to make a settlement, I think the family court can easily twist the arms of the parties and say, bring a parenting plan, bring shared custody. Under Section 12, I am deciding interim custody first. By making an order, I am going to read the word joint custody and I'm going to read into the word parenting plan into Section 12 of the Guardian and Wards Act. I again reiterate Section 12 to say such order for temporary custody. Now, such order means joint or custody order, and temporary custody means shared by a parenting plan. Now, having said so, let us see the duty of the family court. In every suit, proceeding or endeavor made before the family court, the endeavor shall be to arrive at a settlement in respect of the subject matter. Then, if any suit or proceeding, it appears to the family court that there is a reasonable opportunity, family courts may adjourn the proceedings for such period as it thinks fit. Now, in Bombay, I've seen the matter doesn't go to litigation straight, it goes to mediation first. Now, the next thing is the family court free of the shackles of the technicalities of law? Yes. Section 10 of the Family Courts Act says that the procedure of the family court shall be guided by the Civil Procedure Code. But then in the same breath, Section 10, subsection 3 says that nothing in this section shall prevent a family court from laying down its own procedure with a view to arrive at a settlement in respect of the subject matter or arriving at the truth alleged by one party or denied by the other. So, the family court has a complete discretion to run down the procedure. And then, in doing so, we have to read Section 13, right of legal representation. Now, family courts act like the labor courts under the Industrial Disputes Act. It is said that notwithstanding anything contained in this law, no party shall have a right of a family court to be represented by legal practitioners. Then, but what proviso? Provided that if the family court considers it necessary in the interest of justice, it may seek the assistance of a legal expert as amicus curiae. So this is something the court can use, pick up. Bombay has started appointing child independent lawyer. It's a very common feature to have this kind of a representation abroad, but this is something which can happen again. Now then, after the procedure being free from the shackles of the law of procedure, Section 14 frees it from law of evidence by saying a family court may receive any report, statement, documents, information or matter as it may deem fit to effectually deal with the dispute, whether the same would be otherwise relevant or admissible under the Aid and Evidence Act. So second thing, family court is free of the shackles of Evidence Act also. So under Section 14, any document can be taken as evidence minus the Indian Evidence Act. So I think the wholesome remedy is reading section 12 to make such order for temporary custody and reading it with section 9, 10, 12 of the Family Courts Act to say that if we interpret the word to mean such order as a and temporary order, a joint parenting, shared parenting plan can come in. So till the Parliament amends the law, till there is a change in the statute, the words such order and temporary custody can be read down. Reading down is a provision which the Supreme Court says you must do to make the beneficial provisions of an act under interpretation. So I think this is the way I would look at it. And I think some innovation is required. But what do we need to do? I have been talking to family court judges. I think the family court judges, particularly in the northern jurisdiction, need a lot of inculcation. They need a lot of training under the judicial academies. They need new ideas. They need a discussion. They need a portal for coming together. The new lot is very bright, very promising, and has ideas, particularly the ones who have done a 5-year law course, or maybe the ones who are in their early 30s, have very good vision on these circumstances. Now, there is another issue which I must share with you. This concept of shared parenting, joint custody, is not free of any material. If we see the judgment of the Bombay High Court in Tushar Wale, 2016 Bombay 88, AIR 2016 Bombay 88, and Savita Sitaram, 2020 AIR Karnataka 372. There is ample material on how a parenting plan can be brought about. In JK versus NS 2019, SEC Online Delhi 9085, Delhi High Court has also laid it down. My advice as a practitioner, my suggestion as a practitioner is, it is the litigant, it is the lawyer who has to come up with a parenting plan and put it before the court. And I think he should insist before the court that in a section 12 application to decide interim custody, such order will mean a joint parenting plan, a joint custody order. It is a precedent which has to be settled. Family court will settle it, High Court will uphold it, Supreme Court will lay down the law. It will be better if it starts the reverse. Suppose Supreme Court was to do it, it would become a precedent in the shape of practice directions like Vishaka. It would become the law of the land under Article 141 of the Constitution. And it would be, and every due court would be duty bound to follow it. So whether it comes this way or whether it comes that way, I think this is the broad outline and the gist of how I look at it. But what is very disturbing is that starting from 1960, Gohar Begum, and going down to Yashita Sahu, Tejaswini Gaul, Lahari Sakhamuri, there is so much litigation, interparental, between continents when children are split across borders of various countries. It is equally bad when we are within the country. And I think the suffering is more when you are within the country. You live in a town 40, 50 kilometers away. You have a right, but you can't enforce it. There is no remedy available. You complain to the court. The court is not in your matter is not listed. You can't have a hearing. So these are practical issues. And I think the courts have to start looking at this issue in a very different way by maybe giving priority to cases on interim custody and settling them. So these are some of my thoughts. And I think Nalini ma'am may have a different experience of her side of the jurisdiction, and she may add her views. So and then we can put the floor open for questions. Thank you.
Thank you. Thank you, Anu sir. And in fact, it was an eye-opener for many of us in the sense like these are the issues with which child custody or something to do with somebody who cannot take decisions on their own is to be